So Bob didn't mention a report that he did called Minor Crimes and Massive Waste. It was published by the NACDL.
She's too tall for the mic.
Too tall. Good morning. Thank you all for taking time out today to spend time thinking about this issue of crucial importance to the justice and working of the entire criminal justice system. I'd like to thank David and Rob and Carol for having me today. I was just mentioning that Bob did not mention a report that he wrote called Minor Crimes and Massive Waste. It was published by the NACDL, which gives a national overview of the crisis in misdemeanor courts around the country. He mentioned that there are 10 million misdemeanor cases filed every year as compared to about 1 million felony convictions. This is a massive phenomenon that affects every criminal justice system in every state, and Bob has really been a leader in getting information about this system into the public. So we really owe him a debt of gratitude for making it possible to talk about this system with some data that we didn't really have for a very long time. The reason that we talk about misdemeanors, in my narrow personal opinion, is not because they're misdemeanors, but because they really offer us a window into understanding the way the criminal justice system works more generally, and in particular, the vulnerabilities of the right to counsel. A number of people have spoken here today, and I think many of us in the room know that overburdened and underfunded public defender offices can't possibly provide effective representation to their clients. But it is also true, and I want to focus today on additional, deeper structural impediments to effectiveness of counsel, ways in which even skilled counsel with time and resources have been rendered unable to provide meaningful, effective representation to their clients. And the central reason this is true is because our massive modern criminal justice system puts such great pressure on defendants to plead guilty, whether or not they're innocent, whether or not they have viable legal issues in their case, in ways that effectively sideline the role of counsel in ways that the defense bar has very few tools to do anything about. There are many features of the criminal system that operate in this way. I want to just mention a few. Bail, for example, Bob mentioned the phenomenon of bail, but many innocent defendants in this country plead guilty because they can't make bail. And bail is a significant phenomenon. The average pretrial detainee in this country spends between 2 and 3 months incarcerated before any adjudication of their guilt. Of the defendants who are set bail, 80% cannot afford to pay it. And so I want to suggest thinking about this as a form of structural ineffectiveness, a crucial driver of criminalization, a reason that people are pleading guilty that their lawyers really can't do very much about. Similarly, the kinds of delay that we've heard about in these courts, where even when defendants are not detained, it can take so long to adjudicate the merits of a case that many defendants give up. They can't afford the cost of going to court, of foregoing time at work, foregoing childcare. And so the fact that our criminal justice system in many regards, particularly in the misdemeanor system, is not open to setting trial dates, to hearing legal motions, to permitting adjudication to take place, in and of itself exerts pressure on defendants to plead and accept the label of criminal. As many of you may know, 30 years ago, Malcolm Feely wrote about the misdemeanor courts that the process is the punishment. Well, what that means is that once you're in the system, in many ways, your lawyer cannot prevent you from being punished. So today, even if a lawyer gets a case dismissed, right, the gold standard of lawyering, that defendant may already have been incarcerated, punished, humiliated, and burdened in lasting ways. And this too is a form of structural ineffectiveness. Perhaps most importantly, defense counsel in the misdemeanor system can do little or nothing about one of the most unfair and destructive aspects of the misdemeanor process, and that is its racial selectivity. stop and frisk, urban policing, drug enforcement, fill the misdemeanor system with poor young Black men purely through the process of selection, thereby putting pressure on this group to accede to the pressures of the criminal justice system, to plead guilty, to accept the label of criminal. And of course, the selection process takes place long before anybody has the right to counsel. So in these ways, looking carefully at the misdemeanor process and all its dysfunctions highlights some of the inherent limits on the role of counsel, what counsel can do to ensure that our criminal justice system is fair and responsive to defendants. This phenomenon is not limited to misdemeanors. As the late Bill Stuntz here taught us all, the phenomenon of over-criminalization, the sheer breadth of the criminal law, makes it so easy for the government to charge individuals in ways that exert massive pressure on them to plead guilty to something, even serious cases. The severity of the system, mandatory minimums, of course, the famous power exerted by the US sentencing guidelines, the trial penalty built into the sentencing guidelines that exerts pressure on defendants in serious cases to forego litigation, which has become increasingly expensive and risky for defendants, and again, to plead guilty. Many defendants are under severe pressure to cooperate, particularly in the federal system, but also widely in drug enforcement. In effect, when a defendant agrees to cooperate, they're placing their fate in the hands of the government, and in many ways constraining the role of their own lawyers. Again, all these dynamics we can understand as inherent constraints on the ability of defense counsel to make the system fair and responsive. I think there are some useful things we can take away from this somewhat depressing picture. One is to understand that lawyers are most effective when law and evidence matter the most. That's the Gideon model, that we give people lawyers so that lawyers can litigate matters of law and evidence. But when law and evidence doesn't matter so much, as it increasingly does not in many serious cases, and as Bob has described, often doesn't matter at all in the misdemeanor process, then there are a limited number of things that lawyers can do for their clients. One way I like to think about this is to conceptualize the criminal justice system as a pyramid, right? So at the very top, for a small number of cases, law and evidence matter a lot. Serious cases, capital cases, like the kind that we're going to be hearing about today, complex cases, cases before tribunals that are attuned to matters of law and evidence. Here, lawyers, defense attorneys have the most power, the most tools at their disposal. But as we move down the pyramid, as the process gets more quick and dirty, as it gets larger, as law and evidence matter less, counsel loses their power to do things for the clients that we are supposed to do. And of course, it's a pyramid because the bottom is so much bigger than the top. Of course, the misdemeanor system dwarfs the felony system. Serious cases like rape and murder make up about 1% to 2% of all cases. The federal system, which tends to be highly adversarial and relatively open to raising issues of law and evidence, only about 10% of the system. So the bottom really represents, in many ways, how we run the criminal justice system in this country. So the crisis in indigent defense, while it is a funding crisis and a resource crisis, is not only that. It is also a symptom of something that our criminal justice system has become. It has turned into a place where, with less individualization, where law and evidence matter less, where instead law enforcement discretion matters greatly, where the process is more and more about managing groups of people in standardized bureaucratic ways. Given this reality, how should we think about indigent defense reform? So I think we've established for the day that we need to fully fund the defense bar. But above and beyond that, in order for those attorneys to be meaningfully effective, we need to ensure that the things that lawyers do, law and evidence, continue to matter in our criminal justice system in significant ways. So at the top of our pyramid in serious cases where lawyers are have the most ability to effectively represent their clients, we could still make law and evidence matter more. We could push for more and more frequent and more rigorous trials. We could push for more discovery, a more accountable forensics process, to give lawyers more things to work with, more leverage to wield on behalf of their clients. As we move down the pyramid, as the process becomes more like an assembly line, more bureaucratic, we need to think about structural ways to empower defendants and their lawyers so that having a lawyer can be more meaningful in this quick and dirty process. I'm thinking of measures like community-oriented representation models in which not only individual public defenders, but public defender offices can assume stronger institutional roles in the criminal justice system. We can look to class actions like the stop and frisk litigation in New York as ways of pushing back against the indiscriminate sweep of criminalization at the bottom of the pyramid. Likewise, decriminalization measures that we've seen already this morning are a way of thinking about rolling back the misdemeanor process at the bottom of the pyramid, all of this so that having a misdemeanor lawyer can be more meaningful and more powerful. I want to echo a point that Stephen made this morning, that ultimately the right to counsel is a means to an end, right? The end being a criminal justice system that is fair and responsive even to the poorest and most vulnerable defendants. But our modern criminal process has become unfair and dehumanizing in ways that are not really amenable to adversarial testing. And so for too many defendants, especially at the bottom of the pyramid, it is not enough to have a lawyer to ensure their fair treatment. And so in our minds, Gideon needs to mean more than that.